Hi, welcome everyone. Thank you for joining us for our Title IX webinar, Sexual Assault Off Campus, What Must, Can, and Should a School Do? I'm Jackie Godefroy-Warrens, and this is a continuation of our Title IX meetups, which we've held since last summer to help keep you all up to date on the many changes in Title IX. On that front, some big news that we did receive notice from OC on a blog post last week that they intend to issue a Q&A soon on Title IX. So if you aren't already subscribed to our blog, title9insights.com, please make sure to do so that you can receive notice and our analysis from our team when that Q&A is released. And speaking of our team, I'm excited to be joined today by my partners, Amy Dickerson.
Hi.
And Jennifer Smith.
Good afternoon.
Please ask us any questions that you have about jurisdiction or anything else today using the Q&A function on Zoom, and we will do our best to answer your questions. I know we only have a short time with you today, but we are looking forward to covering a lot of ground. So with that, let's jump right in and discuss our topic today, which is sexual assault off campus or sexual harassment off campus, and what must, can, and should a school do? So Amy, why don't you start us off with what the rules of jurisdiction are under Title IX?
Yeah, and I feel like often when we've been having these webinars and talking about the various topics and nuances under Title IX, and especially our new regulations, we're often really focusing in on, what is the big question of, what really is considered Title IX sexual harassment, but often really focusing in on, well, what would be considered hostile environment sexual harassment now under the Title IX regulations, right? Which is that severe, pervasive, and objectively offensive conduct, or if it was employee quid pro quo, or the big four. And so today, as Jackie said, we're really going to be focusing in on the other big key components of what would be considered Title IX sexual harassment, which is, when it would fall within that jurisdictional scope that's now required under the regulations in order for it to be, considered to fall within Title IX. And so that jurisdiction, the rules of jurisdiction now under the Title IX regs is that to be covered under Title IX, in addition to having to meet those definitions of hostile environment sexual harassment, one of the big four, or employee quid pro quo, is that the conduct has to have occurred in a school's education program or activity, and it has to be perpetuated against a person in the United States. So that in the United States is pretty typically clear, although I'm sure there's always nuances there. But specifically in looking at, which we're going to talk about today, more is, occurring conduct that occurs in a school's education program or activity. What that means is that the education program or activity includes locations, events, or circumstances over which the institution exercises substantial control over the respondent and over the context in which the sexual harassment occurred. And for higher education institutions, that includes on-campus and off-campus buildings owned or controlled by a student organization officially recognized by a post-secondary institution. So we're going to talk through now some examples of when the conduct may have occurred within a location, event, or activity or circumstances where the institution exercises substantial control and when it may not. So Jennifer, you want to start us off with talking through some of those examples?
Sure. My colleagues gave me the softball today, which I was grateful for, of, okay, when is there obviously jurisdiction? So the first one, if harassment or sexual assault happens literally when instruction is happening. So in class, in the building, in the bathroom of the building. I'm trying to think of places where you might actually get, I've had in the stairway in the building, or right outside the building, but on campus property. Given remote learning in the year we've had, harassment that happens through remote learning or through a platform that you control as an institution. So the only reason the two people are connecting and engaging is because of something within your control that you have the on-off switch on. So whatever your remote learning platform, chats and Zoom. I've had some situations this year where there's harassment based on, you know, chats that happen in remote learning. Extracurriculars, so your own school or institution events, clearly yes. Again, you control them the same way that you do curricular events. So your athletic events, your arts events, and that includes where you are controlling them. So it could be on your campus, it could be off your campus if it's your event and you've arranged to have that in a facility that's off campus, but it is your event. It's still your event. You're controlling it. It's definitely in your jurisdiction. Sometimes one of the closer questions we get is when a student would be in transit. And definitely when it's in transit within the property, absolutely yes. When it's in transit off property, I think there's a question of how much control do you have over that? So if you're monitoring that transportation route or providing that you know, if it's a campus bus or transportation you hired, absolutely. If it's even across the way, but something that you monitor, like you monitor them crossing the street, well, 1 foot across the street probably is not going to get it outside your jurisdiction if you're literally your safety is monitoring that area because it's a high, you know, it's something that you have to access in order to get to your building, and you've taken on the responsibility of monitoring that. All of that seems to be clearly within your jurisdiction. So from there, I'm going to turn it over as far as, okay, what is not, or what is off campus then?
Yeah, so, you know, if we're looking at, you know, well, what if the conduct is off campus, then, you know, when there might not be jurisdiction. So thinking about instances where there could still be jurisdiction if it's off campus, you know, there could very well be, and it includes those examples of what Jennifer just described. So, you know, if it's off campus, but it occurred online, there could still be jurisdiction. If, for example, it occurs during remote instruction, that's obvious. If it occurs not during remote instruction, but using school devices, school issued iPads or Chromebooks, then, you know, there may be substantial control that the district exhibits over the use of those devices. And of course, we're always looking then at, you know, our policies and agreements that govern those things as well. You know, additionally, if it occurs off campus but in person, again, those examples that Jennifer gave about school-sponsored activities, you know, even if it's off campus, that would still be that would still fall within the jurisdiction, whether it occurs at the school building or at someone else's school building, at a non-school institution at all. But if it was a field trip or some other school-sponsored event in some way where the school is exhibiting substantial control over that activity, those are examples where it's off campus, but where there could still be jurisdiction. Now, other instances where there might not be jurisdiction, both, I guess, those bright line areas maybe, and maybe some grayer areas. Jackie, do you want to talk through some of those examples?
Yeah, so this is where we typically hear from all of you, right? Is the cases where it appears at least that there isn't jurisdiction under Title IX. And so, okay, what do we do next? So the most obvious example of conduct that wouldn't fall under your jurisdiction under the new rules, and this is the same standard that the courts have been using for many years, is if the conduct is an off-campus sexual assault behind closed doors in a private residence on the weekend, or maybe even over summer break, but it's between two members of your community. And so the question is, you know, what do we do then? Does that fall under Title IX? And generally speaking, the answer is clear, which is the answer is, well, no, that specific conduct does not likely trigger your Title IX responsibilities. But one of the things, the main thing we really want to talk about on this is that there may be some instances where that conduct that occurs off campus has enough of an effect on the school environment or creates a hostile environment based on sex within your school, that even though you wouldn't potentially investigate that assault for purposes of determining, did that assault happen, and what should we do about it, you might still find yourself in a situation where you would need to consider if you have Title IX jurisdiction over what they call, often people will call this the downstream effect. But I think that there's a lot of confusion about this idea of a downstream effect. So for a lot of victims, for example, their interpretation of that might be, well, any impact that sexual assault is having on me in the environment should be enough for you to investigate this. But the reality is that what the case law has for many years been telling us is that we're typically going to need to see something more. We're going to need to see an allegation that the clear example is that the victim, after reporting the conduct, is being subjected to harassment by the alleged perpetrator or their friends at school. And somehow you catch wind of the fact that that is happening and that the bullying is occurring. Another example might be if the alleged victim, if the complainant were to come to you and say, I'm feeling, these incidents have happened on X, Y, and Z day, and I've had these interactions with the respondent, the alleged perpetrator, that are impacting me at school. It is never, and I'm very curious to hear from Amy and Jennifer on this, but in my experience, it is not usually very clear in the moment what you are being asked to do, what's being reported, what is involved with any response that you would need to make. And I actually don't know, Amy, but we were talking about this before, or we are going to talk about it. What do you do if you get one of these types of complaints? So maybe I'll leave it at that for now, and we can come back to it. I do want to mention too, the internet. Amy and Jennifer both mentioned the internet and how conduct. So Amy mentioned, if you're using school devices, or if they're doing things during remote instruction or remote classes, well, that's going to trigger your jurisdiction. But speech can also be a little bit more sticky to the school environment than a lot of other things. So unlike a sexual assault that's behind closed doors, it can never come out of that room. When speech is on, when you're dealing with sexually harassing speech on the internet, I think that's another instance where you could have Title IX jurisdiction over a report of misconduct that's occurring off campus, even though it's not through your own technology and those types of things. So with that, let's talk about the other part of this, which is, what if the conduct is outside of Title IX's jurisdiction? What does that mean, and what do educational institutions do, Jennifer?
Sure. So then you're, in that case, you're looking at other authorities to see what happens. So what are the other policies or other laws that apply in that situation that require action, or that frame up what you're going to do? So it may be things like athletic code of conduct, student codes of conduct, other activity-specific participation requirements that you can still apply. Title IX, just because Title IX doesn't apply, they explicitly say, but other requirements may still apply to this situation. So For example, one of the jurisdictional things is overseas. Title IX doesn't apply overseas. Well, if you as an institution still have overseas events, you might want to make sure that your participation requirements or your codes of conduct or some other trigger allow you to address behavior that is contrary to that activity, because you're going to want to address it and you won't use Title IX. So same with athletic codes are I'm getting a lot of questions about that. So we have activity that's not Title IX. Can we still give a consequence to an athlete? Well, let's look at your athletic code and see what it says. So that is the main thing. The truth is, if there's nothing, then you can still counsel victims on where else they could go to seek support. But if you have no policy, no law that you enforce, then you're not going to be investigating and issuing a consequence to the alleged wrongdoer, but you can still then in that situation support the alleged victim who may have needs that could be addressed by you, whether or not there's a consequence to the person who allegedly violated that person. So, and we can obviously talk about one of the most interesting ways this comes up is around speech. And obviously we have a case now before the Supreme Court, and the jurisdiction of when you can address speech is sort of a longstanding, complicated issue. Actually, I was reading or listening to the New York Times Daily podcast, and they were talking about how complicated it is, and I was just feeling very appreciated that the New York Times was acknowledging how difficult education attorney's job was. But Jackie, do you want to talk a little bit more about the complications as far as speech when you're talking about off campus?
Yeah, so, and I'll just say one thing too before we go to that, which is that the time to think about how you want to handle these types of things is right now. It's not when you receive a complaint or a report and then you're calling us and saying, what can we do? Because at that point, you're sort of bound by your laws that are in effect at the moment that you received the report. So you can't change them at that point to make them into what you would want to be. So what I would encourage you to do is to ask yourself, what would I do based on my institution's policies and procedures if I received this type of report of off-campus misconduct today? And go in and look at your policies and procedures, look at all of them, because sometimes one will say one thing and another one will say something else. And figure out what it is that you want to do and do that now. Make those changes now.
Jackie, that's such a great point now, because especially now, that is a time where a lot of schools are reviewing their policies, just finishing up the school year, getting ready for the next one. We know a lot of you have already done this. We know some of you are like, we got to get on this. But it's especially seasonally now a really good time to start doing that.
Right. And if you want help, you can always come find one of us and that we'll assist you. But, it's much easier as the attorney to help you figure out what you want to do before you get a complaint. Once you get the complaint, as Jennifer said, usually we're looking, and if your athletic code of conduct doesn't allow you to impose discipline, then we're going to tell you that you can't do it at that point. And that can be frustrating.
Yeah, just to summarize or sum up what we're suggesting, it's not a review. We're assuming our clients, at least if they're our clients, we assume that you all have good Title IX policies and procedures in place. What we are suggesting is, okay, now that there's some holes and we're talking about this jurisdiction, are you okay, so to speak, with those holes? Or are those things you want to address through your codes of conduct or other types of rules for those activities? So make sure, those are the kinds of things that can be rather in the weeds and individual to your programs. So making sure there's not gaps in where Title IX leaves off and where your institutional expectations picks up.
And then as far as, I guess the question, as I would put it, is kind of, well, what we're talking about, can you impose consequences for conduct that occurs off campus. And I think the initial question that a lot of people have is, well, why would we want to? Or, you know, why would we do that? And so, I mean, the first response to that you often hear is, well, why wouldn't you? Right? I mean, we often extend our jurisdiction to students to all sorts of things that happen off campus. And so why wouldn't we want to do that here? Now, I think there's a good answer to that, which is that sexual assault is a really challenging thing to investigate and to determine whether or not there's sufficient evidence to establish that it happened. And schools just aren't the best arbiters of those disputes. The best arbiters of those disputes are law enforcement and civil and criminal courts, who are, you know, the experts in how to do these types of things. And so I think many schools, rightfully, particularly K through 12 schools, who often lack the amazing budgets that a lot of, you know, the higher education institutions, at least the big ones, have for Title IX. It's like, well, we shouldn't be doing this because, you know, this isn't even something that happened within our environment. We do often go after speech that occurs off campus more frequently than we do other types of conduct in, again, particularly in the K-12 realm. I think colleges and universities tend to be more willing to extend their kind of long arm jurisdiction outside of the community, and that's okay. And if you choose to do that as an institution, just make sure you're doing it even-handedly. But when you're thinking about doing it even-handedly, I would encourage you to think about speech as being a little different than other types of conduct. What I always encourage people, what I always ask administrators is, what would you do if it was a fight over the summer between two students, you know, at maybe it was in another state even, right? They're traveling or something and they get in a fight. Would you be investigating that? Would you be imposing consequences on that? If so, then maybe your jurisdiction does want, maybe you do want to reach sexual assault, because it wouldn't really be a difference between those. I think there are a lot of people who are, you know, on the far opposite end of the spectrum, who say, why in the world would we ever take this on? And I completely appreciate that and understand that, but just encourage you to remember to keep in mind those things like the downstream effects that we talked about. We're going to talk about that a little bit more, about the supportive measures that you might want to put in place for students who are involved in these kinds of incidents, even if you want to take the approach that, you know, we aren't going to get involved with conduct that is purely happening off campus and that doesn't have any connection to our school environment. So I guess with that, Amy, let's talk about, you know, what happens, what do you do if you receive a report of off-campus misconduct?
Yeah, I mean, so the biggest thing, and I still hear it from time to time, is, you know, a parent saying, or someone saying, oh, well, you know, the administrator said, oh, it happened on, you know, Facebook or Instagram or social media, so we can't do anything about it. Don't do that. Don't just disregard it just because the complaint or the report occurred off campus or occurred online. So, you know, if it's off campus sexual misconduct, you know, as we've discussed, and for all the reasons we've discussed, if there's nothing, you know, technically to do, your Title IX policies will not be triggered if there is no jurisdiction. So if you are considering the jurisdictional examples and rules that we've talked about, and it wouldn't fall within Title IX, then there wouldn't be anything required under Title IX. But then from a policy standpoint, in terms of what policies or procedures would apply, that's when you want to consider whether there would be jurisdiction under any other part of your student code of conduct. And oftentimes, you know, if we are talking about harassment, bullying conduct, likely if there is, it may require you to go through that analysis of your, is there a sufficient connection to the school environment, and go through those typical analyses that we do. But oftentimes, even if it doesn't fall under Title IX, you not only may have the authority to address it in some respect under your code of conduct, but may in fact need to, depending upon, what the conduct is. And so, from a general approach standpoint, you want to proceed with responding, in accordance with your policies, even if you identify that, this would fall outside of Title IX jurisdictional scope. And that is not always clear. And oftentimes that's some of the conversations we're having with all of you on the phone is, okay, this came forward. We don't think it applies under Title IX based on these rules, but we want to confirm with you. And, what you may hear from a practical standpoint is, it may still be both, appropriate and a good practice legally to still have, if a report comes through, that initial supportive measures meeting with the alleged victim when you get that report, and to talk through what might be available, even if you think that Title IX may not apply, but to have that dialogue from a support standpoint, to ensure that the student safety and support, to explain, what policies or procedures might apply here, what type of information you have, and what's, what step you are, how far you are into the process in terms of collecting information. That may all determine what that conversation might look like. But that way you can have that initial touch point, with the alleged victim of the conduct. You might be able to get a little bit more information, and perhaps from that information, you might help. It may be something that then you get more information that does trigger your Title IX policies, but then you're having that dialogue. And if it is a gray area, and there is a formal complaint that ends up being filed, in which case then you would have that obligation, as you know, to then review to see, does it fall under Title IX? Do we have to dismiss it under Title IX? But if that does happen, and if it is one of these gray areas, you would have already had that initial meeting. And if it is that initial meeting, or if you do determine that Title IX doesn't apply, but that other policies or procedures do apply, and that's how you're going to approach it, we recommend documenting that decision in some way, whether it's minimally in an internal document, or whether it's communicating that to the parties to let them know, which procedures or policies you've determined apply, so that if there were ever to be a challenge under Title IX, that you have got some record that this is something we considered, this is why we determined Title IX didn't apply, but this is how we proceeded elsewhere.
So Amy, real quick, since I think we're right at one, there was a question in the chat about if you're providing supports for the victim of an alleged allegation off campus, would you also offer supports to the alleged perpetrator? And if this is an outside case that is going to downstream into campus with rumors. So first of all, yes, I think that's a good idea. That you should give supportive measures. Even if you're not taking it to investigate, but you're ensuring that you're not deliberately indifferent to the allegations and you're concerned about that downstream impact onto your campus, a great thing is to offer supportive measures type intervention to both parties. And I mean, sometimes the best thing you can do is, so one of those supportive measures is keeping them apart. So offering that to both parties is effective, and maybe both are very agreeable to whatever steps to keep them apart. But yes, so I would say yes to the answer in the chat, and brainstorm about how that could really be effective in ensuring there aren't those downstream effects and preventing that type of a claim.
Right, and I think this is where, we have this we always have these beautiful conversations when we're prepping for these that I always want to recapture and share with you all. But one of the things is like, you know, the requirements of Title IX they're probably lower than what you may want as an institution to do. And that's okay. I mean, as Jennifer mentioned earlier, the rules say if you want to use the Title IX rules for every complaint that you receive, you technically are allowed to do so. I might question you if you chose that route, but you can do it. And there's nothing to stop you from providing supportive measures to both parties who are involved, to checking in on them regularly, to, and all of those things are always going to help the lawyers down the road if we're defending your actions. But I also think, for many of the institutions we work with, there are things that they want to do. So don't feel constrained by what we're telling you today. It's more just an effort to hopefully get you to think about what your jurisdiction looks like, your institution now, and get yourself set up for if you receive a complaint down the line. Well, thank you everyone so much for joining us. We will see you again. I think we will probably shoot for our first Tuesday of the month of July 6th, but we'll let you know if for any reason we push that back because of the holiday. But have a great month of June, and we'll see you in July, everyone. Bye-bye.